Today is arguably the best day in crypto. It's certainly the best day in crypto in the last 3 years. We got the decision today, as all of you should know by now.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
Today is arguably the best day in crypto. It's certainly the best day in crypto in the last 3 years. I got to tell you, even Ripple haters, XRP haters, are saying, great job. They're saying, I never thought I'd say this, but thank you, XRP. We got the decision today, as all of you should know by now. And the one thing that I really feel validated about, believe it or not, is my faith that Judge Torres, along with Judge Netburn, were the good judges. If many of you remember when we got the judge, because you don't know which judge you're going to get in the Southern District of New York or many other districts. And when we got Judge Torres, I did a little research. I read a couple of her summary judgment decisions. I saw that she had been critical of the Department of Justice in the past. And I saw a judge who sort of ignores the bullshit and ignores the noise and just applies the law. And at the end of the day, that's what you want. And a judge who's not afraid to call it something out, to call the government out if that's what needs to be done. And so to a lot of the people who were so frustrated about how long it took, who started doubting her and doubting, is she in bed with the SEC? Hopefully you have a little bit of faith restored, okay, that we had a judge who applied the law. And when you apply the law objectively, you get the right decision in this case. Remember what I said before. I said that early sales of XRP in those early days could be construed as an investment contract, but that this approach that selling them in the secondary market, buying it off Coinbase or Uphold or Kraken, that those were also investment contracts, that's nonsense. And today, that's what we got. And so I'm going to take you through the opinion real quick and highlight a few things. And yes, XRP holders are cited. The judge cited all the amicus briefs that she read them all. Spin the Bits, XRP holders, Digital Chamber of Commerce, all of the ones that were submitted, because this is a conscientious judge. And XRP holders' affidavits, I'm going to show you how they made it into this opinion. And so I want the people to feel good about themselves, right? People who waited patiently, people who participated and took the time to sign an affidavit, get it notarized, who didn't mind their name being out there, who wasn't fear of retaliation by the government, who said, I just want to have my voice heard. Well, your voice got heard, and I can show you what I mean by that. So let's go through the opinion real quick. An exceptionally concise, well-written, well-analyzed decision by Judge Torres. Very methodical, very simplistic. She stuck to the facts and the law and gave her decision. And if there's one thing, I can only think of one criticism, and I've only read it through once, and I'll share that in a minute. But let's go through it real quick. She starts off with showing that she understands that the XRP ledger was open source. She talks about how anyone can access it and utilize the ledger, send a value over the ledger. That's important. People can run a node to be part of the validation process. And she talks about how there are independent developers who are on the XRP ledger that have nothing to do with Ripple. She doesn't say it in those exact words, but she does say other developers. The way she says it is other developers have built software products that use the XRP ledger, such as payment processing applications. And I know one of those developers was Spin the Bits, which is a payment app on the XRP ledger, completely independent from Ripple. And so this is a judge who took her time to learn these things. And she talks about how XRP was meant to be a better version of Bitcoin. And she goes through that history. And then she says, the XRP ledger is based on open source software. Anyone can use the ledger, submit transactions, host a node to contribute to the validation of transactions, propose changes to the source code, or develop applications that run on the ledger. And so that's how it starts. And then she gets right to the point and says, listen, at the end of the day, the question here is, did Ripple violate Section 5 of the 1934 Securities Act? And she basically takes the SEC's summary judgment, where they basically, in the complaint, they do this as well. They break down, in essence, 4 categories of sales of the XRP by Ripple or their founders or the 2 executives. So the first type of sell is called institutional sales. And that's basically to hedge funds. And what's interesting about this decision is that, and I'm going to explain to you, Judge Torres rejects the Ripple argument of essential ingredients and the pre-1939 blue sky laws argument. She says, hey, you can't cite one case that's ever cited this essential ingredients. It's outside of Howey. I'm not going to go outside of Howey and apply something else that the Supreme Court itself hasn't applied. Very rational decision. But what's interesting is she says, I'm not even going to get to the issue that you have to have a written contract before you can have an investment contract. I don't need to get there, because the only sales of XRP that I find to be unregistered securities are the ones with written contracts. So she goes, I'm not even going to go down that road because I don't need to, because all the ones sales of XRP that didn't have contracts are not securities. And so fascinating the way that she lays this out. And I've heard people talking about, oh, it's going to get appealed immediately by the SEC to the Second Circuit, and it could get overturned. Theoretically, could it get overturned by the Second Circuit? Sure. And then it'll go to the Supreme Court. And with the Supreme Court, but this is very difficult to overturn, in my opinion. There's going to be people that disagree with me, but they cannot basically criticize her for the reasoning, in my opinion. Now, that's the institutional sales, right? And then there was a second kind of sell, which are through exchanges. They're called programmatic sales. Basically, Ripple is selling XRP through Coinbase or any other exchange. And she makes note that those sales are blind sales, the bid and the ask, right? You don't know. We don't know when we go on Coinbase who we're buying XRP from. We don't know whether it's Ripple. We don't know whether it's, a founder. We don't know whether it's Moon Lambo cashing out at $4, some of his XRP. We don't know who it is. And so how can you rely on the efforts of the other when you're unaware of who that other is? Sort of some common sense applied here. But the institutional sales, the first category I told you, the SEC said Ripple raised $729 million. The programmatic sales, which are on the exchanges, was $757 million. And then you have this third category called other distributions. Basically, it's Ripple paying contractors or developers or even employees XRP as compensation. And that's the other one. Well, Ripple, the SEC said, raised $609 million selling XRP to third parties through these other distributions. And then the fourth category of sales was Brad Garlinghouse and Chris Larson selling in their individual capacities, not as Ripple, but as individuals, their XRP on exchanges, and that Chris Larson sold 450 million worth US dollars, and Brad Garlinghouse sold 150 million. And now Brad Garlinghouse and Chris Larson had a defense, which was that their sales were in foreign jurisdictions, where XRP is not a security, and therefore there's no jurisdiction here. The judge in a footnote says, I don't even have to get to that. And the reason I don't have to get to that is because I'm finding that Chris Larson and Brad Garlinghouse sales of XRP on exchanges where it's blind, you don't know who, the buyer doesn't know the seller doesn't know the buyer, that's not a security. Just like when Ripple sold on exchanges, that's not a security. And so the only sell that was deemed an unregistered security was the institutional sales, hedge funds. Now, the one criticism that I would have is that in her opinion, she basically defines institutional sales as sales to hedge funds and ODL customers. And I think that should be distinguished, because we all know, and Bill Morgan has been someone who has been very vocal about this, more so than me and other people. So make sure that he gets credit for that, which is that ODL, because the ODL customer sells the XRP back after a few seconds, that how do you rely on the efforts is not an investment, it's just a transaction. But the judge just grouped it in there. And so that's one potential problematic area. Whereas in the future going forward, is the SEC going to try to, make hay with ODL sales? And so that's the only thing after my first reading of this decision that I saw as potentially problematic in the judge's analysis, because I really don't think ODL sales can be grouped as same as selling to a hedge fund who really is relying on some efforts of Ripple who are going to sell it later for a profit. Okay, so that's basically, she lays that out, and then she just goes over a few facts. She talks about the marketing that Ripple did. And you could tell the judge brings up things that I brought up in the amicus brief, which is, listen, Ripple sent a brochure to 100 people. If you can prove those people bought XRP relying on the promises and marketing of Ripple, then go at it. That's a direct sell from Ripple. But some brochure that was sent to 100 people in 2014, or some Twitter statement that Chris Larson said in 2015, when many XRP holders, the 6 XRP holders that were individually named that I represent, not one of them were on Twitter back then when those Twitter statements were being made. So you can't basically just take some statements and then apply it to the world. And the judge basically, in so many words, took that to task. And so the judge talks about the legal memos after the marketing. She then says that she read all of the amicus briefs. And then she takes the next few pages and she dismantles Ripple's essential ingredients case and test that they wanted to invoke. And so that's in essence what happened. Now, the thing that I want people to know is that the judge rejected Ripple's argument about essential ingredients and you have to have a contract, but ultimately the only sales that were deemed unregistered securities were the ones where there were written contracts. And in those written contracts, there were restrictions on selling, and there were other things that the judge said clearly. And what she did with all those different types of sales that I just told you, the institutional, the programmatic, on the exchanges, and then the other distribution to employees as pay, she literally takes each one and she does a Howey analysis for each one. And when we get, for example, to the others, giving XRP to your employees, the judge says that doesn't meet the first prong of Howey. and then says, since it doesn't meet the first prong of Howey, I don't even have to get to the other prongs. It's just not, they didn't pay any money for it. She also talks about how Ripple used XRP for third parties, or Ripple gifted XRP. I think that's important because of airdrops. You know, there's no money spent for airdrops. And so I think that there's some good stuff in there for other types of cases as we move forward, or arguments. And so then the judge absolutely does what the judge in Library wouldn't do. You know, in Library, we said, Judge, you shouldn't have to, but can you just make it clear that the token itself is not a security? Well, Judge Torres hits it head on, and she goes on and she says, everything that I and other people have been saying from the beginning, the underlying asset is not the security. It's never the security. The orange groves weren't the security. The beavers weren't the security. The Bitcoin wasn't the security. The chinchillas wasn't the security. The whiskey receipts weren't the security. Just like XRP is not the security. And the judge made that clear. And then she says, she actually talks about something that I talked about a lot. A lot of times, remember when I said, if just because the Howey orange grove, you relied on Howey and you entered a common enterprise, but then if that person died and their estate sold the orange grove, it wouldn't be an investment contract, especially if the person had no knowledge of the Howey stuff. And Judge Torres actually talks about, for instance, if the original orange groves in Howey were later resold, those resales may or may not constitute investment contracts, depending on the totality of circumstances surrounding the later transaction. What's that mean? Many of you seen me battling a few people on Twitter who say I was wrong when I said that you have to apply Howey at each sell. That's what an investment contract is. And I said there's not a single case in the history of the United States where there's no privity between the promoter, issuer, and the buyer, and there was an investment contract. And there's not a single case in history where the second sell was deemed also an investment contract just because the first one was. In fact, the only case that dealt with it said otherwise. And that's basically what the judge says here. So for those people that I was battling, could you please shut up? Because I'm tired of arguing about that. To me, it's common sense.